Well, hello everybody. This is Josh Becerra from Augurian. I'm here with Megan Upperman.
Hi, I'm Megan. I'm the Analytics Manager here at Augurian.
Yeah, so we're hanging out at the Stray Dog again. We're going to be talking about GDPR. Megan brought this topic to my attention here recently. What's happening in January?
Yeah, so in January is when the California protections go into place. So CCPA for consumer data is going to take into effect on January of 2020.
Okay. Yep.
And then B2B rules, we have one more year to get into compliance there.
Okay.
Yeah, so the search demand has just really been ramping up, and we've seen a ton of really good questions come through. GDPR specifically, it applies to people who work within Europe, but there's a lot we can learn from GDPR about how to roll that out successfully for CCPA here in the US.
One of the questions we're seeing in the search demand is Google Analytics compliant with GDPR? So what do you know about that?
Yeah, well, and that's just a really good question because it can be, but it also could not be.
Okay.
It really depends on how you have it set up. So, I mean, by default, there's a lot of settings that, have been rolled out for about a year. Around May of 2018 was when they first kind of rolled out the introduction of this. That's when GDPR first went into effect.
Yep.
So, since then, there's a lot of things that Google has done to step up their compliance, but a lot of it they put in your hands to make sure you utilize those tools.
Okay.
So, everything from making sure that you anonymize your IP addresses, to making sure that you understand how to use the deletion tools.
Yeah.
It's very possible to be compliant, but not by default.
Okay. So another one of the questions is around liability, right?
Yeah.
So as a marketer or an agency, what kind of liability do I have if I'm not complying?
Yeah, so this one, it seems a little scary off the bat, but the short answer of this is, from the perspective of marketers and agencies specifically, it's not something you need to sweat.
Okay.
There's no, like all legal matters, it depends on what precedent has been set and, what's gone into effect in the courts, but realistically, it seems like we can all relax on any individuals being held to account.
Yeah.
And it really seems too like from the agency perspective, we're likely not to be held to account there either.
Yep.
Although I can't imagine if you're found out of compliance that your client would be terribly happy and want to stay working with you for long.
Yeah, right, for sure.
Yeah.
So it's all about legal precedents, and we're really still pretty early. There isn't a ton of that necessarily out there, especially not holding individuals liable. So that's a good thing. It makes people feel more at ease.
Yeah, and from my perspective, the most important thing for me is just to know enough to be able to raise my hand and say, hey, you might want to run that past your legal department,
There you go. Very smart. So another question is around consent, whether it's always required and if you can actually get verbal consent. What do you find out about that?
Yeah, so this was actually a really interesting question too. So yes, it's always required for everyone who interacts with European users.
Okay.
So far, nobody has tested the verbal consent argument in court. So I would couldn't tell you specifically that won't work, but I'm assuming that one's not going to hold up very well. It seems like pretty thin. Generally though, the agreement here is that consent has to be freely given, specific, informed, and it has to be an unambiguous indication of the subject's agreement to the processing of that data. So really, it's got to be specific.
Sure. Yeah. I think for a long time it's been like agree to the terms of service, and you just click a button and you're on your way.
Yeah.
And now they're requiring you to actually say, no, here's what I'm actually going to be doing with your data and getting that consent. So,
yes.
All right. So what happens if people opt out? They see all these things and they're like, no way, I'm not giving you my data for that. What happens then?
So this was actually my favorite question that we researched so far. So it's not really enough to just have a kind of a yes or no option. You see a lot of those sites that have you accept their cookies and privacy terms at the bottom of the site there. And what isn't really okay, that was proven really in court like the day after GDPR rolled out, was that you cannot then bar someone from using your site. That all or nothing approach is, it's kind of considered manipulative, right? Because people still want to be able to use your products.
Yeah, either you accept these terms or you don't get to look at my site. So that's not allowed.
No, that's not allowed. So you have to have the alternate option to be able to, have people use your site but not store their data.
Right.
And one of the cool things we found about this is actually something I had come across and I didn't really understand, a couple of years ago why this was configured this way.
Okay.
But you can actually use Google Tag Manager to turn on and off your analytics tracking based on the response to that cookie question.
wow. That's
yeah,
very
so
cool.
that's a really good workaround. You can come up with all kinds of creative solutions,
Sure.
but that's my favorite that I've seen.
Okay, awesome. That's great info. So at the beginning of the segment, you mentioned this CCPA. So can you tell us a little bit about that and then what the difference might be with GDPR?
Yeah. So, I mean, with GDPR, it's really centered around enthusiastic consent and fully informed consent.
Yeah.
So we're looking at things like, data's got to be processed lawfully, fairly, transparently. You have to be able to delete it. You have to be storing it securely. It has to be kept accurately. And you can really only do with it what you specifically said you were going to do with
Right.
it, right? So anything beyond that is going to be outside of regulation. With the CCPA, it's a little bit different. It only applies to the last 12 months of data collected.
Okay.
And it doesn't have to be deletable. That's still something you can do. Analytics still offers those features to us
Yeah.
here in the US. But realistically, if you have opted in to sharing data with third parties, it doesn't mandate that you're able to withdraw that consent later. GDPR does allow you to basically in real time control exactly who has your information and where.
Got it.
The CCPA is a little bit looser around that. So, you'll give the consent one time, but you don't necessarily have to be able to revoke it later.
I see.
So there's that, and then really, in addition to that, it's just much more strict on all your documentation and your requests, and your consent needs to be in very plain English.
Got it. All right, well, last question that we kind of researched around this topic was about email addresses. So
Yeah.
you've been collecting email addresses all this time,
Yeah.
and you may not have been doing that in a compliant way. So can you actually keep and use those email addresses or not?
Yeah, so I'm about to give the famous answer of all marketing people. It depends.
Right.
So basically,
And politicians.
yeah, exactly. So can I use my precious email list? The answer is sort of.
Okay. It depends.
It depends.
Yeah.
It depends. So if you collected those email addresses in a way that is compliant, you absolutely
You're good
can
to
still
go.
use them.
Right.
But if it's not compliant, I mean, some of those common pitfalls to watch out for, for example, at the bottom of a contact form, there's a lot of the times people have a checkbox there that lets you opt in or out of marketing communications
Right.
outside of just the contact form.
Yep.
If that box is automatically checked, it's not compliant. So,
see.
that's a big one.
Okay.
If it doesn't explicitly spell out that it's for commercial marketing purposes, again, then that one's not going to be compliant
Okay.
either. So generally speaking, if you have just a regular subscribe to our email list form there, that's totally compliant. And you
Yeah.
can definitely still use those email addresses.
Okay.
If it's a separate form, that's a really good benchmark for knowing that things are totally compliant. I would basically just caution you, though, to make sure that you do a little bit of research if you have an email list and you're worried about your compliance,
Yep.
because there's other things that are going to impact you, like can spam laws and other things that have been in effect for a
Right.
while.
Sure.
Well, this has been great, super informative and super helpful. I hope all of you also feel that way. So thanks, Megan.
Yeah, absolutely. And if you have other questions around your compliance, definitely feel free to give us a contact.
All right, thanks everybody, bye.